My name is José Gallardo. As of July 28, 2026, here are 3 U.S. immigration developments we are following this week. We will separate what has already taken effect from what is scheduled to change, and we will distinguish government statements from reporting and legal challenges. This is a neutral news summary, not legal advice. First, a new Department of Homeland Security interim final rule changes how some affirmative asylum applications can move through the system. Beginning July 28th, USCIS may refer certain applications directly to immigration court without first holding an asylum interview. USCIS will still conduct an interview before it approves or denies an application itself, and interviews remain required when another law or settlement requires one. DHS says the change is intended to reduce pressure on affirmative asylum backlog of more than 1.4 million cases. The rule cites 444,724 pending applications filed more than 1 year after the applicant's last entry or with no recorded entry as of December of 2025. Critics argue that moving cases to immigration court could add pressure to a separate court backlog and place applicants into removal proceedings sooner. The practical effect will depend on how USCIS uses this authority and which cases it refers. The rule is effective now and is open to public comment for 60 days. Next, a Reuters investigation published on July 28 details a major expansion of information sharing between the Office of Refugee Resettlement, the agency responsible for unaccompanied migrant children, and ICE. Reuters reports based on internal government data that ORR shared more than 460,000 leads concerning children, sponsors, and household members from January 2025 through mid-2026. The reporting links those referrals to more than 12,000 arrests, including sponsors, household members, and some children. ORR told Reuters it does not take part in arrests. DHS says the information sharing helps locate children and identify sponsors who were not properly vetted, including some people with criminal records. Former ORR officials and immigrant advocates argue that using sponsor information for enforcement can discourage relatives from coming forward and keep children in government care. Because the figures come from a Reuters investigation, they should be attributed to Reuters, not presented as an independently verified public statistic. This story is about both enforcement and the changing role of a child welfare system. Finally, DHS has finalized a rule that would replace duration of status with fixed admission periods for F, J, and I visa holders, mainly international students, exchange visitors, and foreign media representatives. The rule is scheduled to take effect September 15, 2026. For most F and J visitors, the authorized stay would generally match the program end date, up to 4 years. People who need more time would have to apply for an extension of stay. The rule also sets a 30-day grace period after studies or authorized practical training, replacing the previous 60-day period for many F1 students. DHS says fixed dates will improve oversight and program integrity. University and other commenters have raised concerns about additional paperwork, delays, and uncertainty for longer programs. Nothing changes simply because the rule was published. The effective date and transition provisions matter. Students and institutions should review official guidance before making decisions. Those are the 3 developments we are following this week as of July 28, 2026. Immigration policy can change quickly through new rules, court decisions, and litigation, so always check the date and the status of a source before acting on it. The links used for this edition are in the description.